Hi everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today we're going to talk about the recent New York jury verdicts and settlements for serious injuries, specifically for fusion cases, namely anterior cervical discectomy and fusion, which is a type of back surgery to the neck area, to the cervical spine, as well as lumbar fusions, which is a type of back surgery to the lower back or the lumbar spine. So let's look at the most recent ones. We could start with the most recent ones. According to this database that I'm looking at, the most recent one I see is from October of 2023. And this is a case from Westchester. And what happened here was there was a plaintiff, and she was a passenger on a bus. And what happened was she was driving on a one-way road, pulled over slightly to the right to stop at a bus stop, and began to make a left turn and collided with another bus, which was attempting to pass that first coach or that first bus. So the plaintiff argued that the other bus's side view mirror came crashing through the window of the bus a few rows in front of her, and she got up from her seat to avoid the mirror and made contact with the wall of the bathroom stall on the coach. And she sustained injuries to her neck and shoulders and was required to have a surgery known as a discectomy and fusion from the C4 through the C6. So that means C4 to C5 and C5 to C6 were all fused. So those bones, those vertebrae, were fused together. Usually they put in a plate and screws, and the idea is to have everything fused or unified, like make a union of it. And then you lose movement at those levels. You lose range of motion. So, and then she also needed a laminectomy at L4, L5, which is another serious back surgery in the lumbar. And she argued that the defendants were negligent in failing to look to the left and see the approaching bus, and to make and that they made an unsafe left turn. And so the defendants argued the plaintiff acted unreasonably in jumping up from her seat, and they claimed that the plaintiff was the cause of her injuries by leaving her seat and failing to wear a seatbelt. And so the case went before a judge. Now this was in Westchester, and the date of the verdict was October 2nd of 2023. And the breakdown was as follows. There was $210,000 to plaintiff for future pain and suffering, and there was $1,290,000 to the plaintiff for future medical expenses. And the total amount was $1.5 million. So you see, this was two different surgeries. They had enough of a policy because it was a bus. And it seems like the jurors in Westchester tend to be kind of on the conservative side. And you kind of see that by the award, right? They're allowing for nearly $1.3 million, but for medical expenses, they probably had a doctor talk about future medical costs, physical therapy, prescriptions, future surgeries, whatever was needed. But then, for some reason, there's no award listed for the past, which is kind of interesting. I'm not sure why, but in terms of the future numbers, 210 seems kind of low for this kind of injury, for the quality of life damages, for the human damages, for the loss of enjoyment of life, for the pain and suffering, all of that, right? It seems kind of low, but then 1.3 seems like a pretty good number for the future. So that's 1.5. And that was October 2nd of 2023 in Westchester. Okay, let's go to the next case. The next case is actually out of Erie County, and that's that's upstate. And this case was actually a defense verdict, meaning the person got nothing. And what happened here with plaintiff, she was also a lady, 36-year-old lady. She was a passenger in a car driven by the defendant when he reportedly rear-ended another car that was stopped in front of them. and the plaintiff claimed to suffer a cervical disc herniation, cervical and lumbar radiculopathy, progression of an L3, L4 disc herniation above a prior fusion, aggravation of a pre-existing C3, C4 disc herniation, an annular tear at L2, L3, chronic pain, muscle spasms, insomnia, and she asserted negligence in traveling too fast for the conditions and following too closely. The defendant stipulated that he was at fault for the accident, but disputed the nature and extent of the plaintiff's injuries, claimed injuries. They use this word claimed again. I did a video about that. I don't like that word, but you know, it's interesting, but it depends on how you frame, how you look at things. But anyway, the jury agreed. I guess the defendant was probably arguing, it doesn't say too much, just like that. What I read is basically all it tells you, so it's kind of limited information. But probably, I'm guessing the defendant was arguing that she had all this before, since she had a prior fusion, and the aggravation of the pre-existing disc herniation wasn't really worth anything. So I guess this plaintiff needed to show how that prior fusion got worse and how she was already vulnerable, she was already fragile, and kind of like this crash is what pushed her over the edge, right, and made her worse. But for whatever reason, the jury disagreed, and the jury awarded 0. And the jury actually said that it's not worth anything. So that's tough. That's tough up there, yeah. And here's another one. This one is from Dutchess County. That's also upstate, not as far upstate as Erie. Erie, I think, is like more like Buffalo up there, really upstate. Dutchess is upstate. Here's a case where this time it's a gentleman. He was driving a car when he was involved in a collision with a vehicle operated by the defendant, an individual, and the plaintiff claimed to suffer right foot injuries, including a navicular fracture with dislocation, requiring open reduction internal fixation, and he had what's known as a subtalar fusion. Okay, so that's a different kind of fusion. That's a fusion of the foot. And he asserted negligence, and the defendant argued that she came to a stop sign due to a large tree branch in the roadway when she was rear-ended by the plaintiff's car. And she argued the plaintiff had a significant pre-existing right foot condition which contributed to his claimed injuries. And again, the jury allowed for 0. They said that it's a defense verdict. And I see the plaintiff used a doctor from Brooklyn, an orthopedic doctor from Brooklyn that went up to handle this case. That's interesting. But, you know, it doesn't really say why. So you'd have to kind of get the trial transcripts and really dig deep to figure out why. But you see, like, upstate is tougher. Now, here's a case from Brooklyn. This is Brooklyn. This was a case in June of 2023, also fairly recent. And here, a lady, a 30-year-old lady, was lawfully standing at the entrance to a building owned and managed by a realty company when a portion of the ceiling fell and struck her on the head, causing her to fall to the ground. And she claimed to suffer loss of consciousness, disc injuries, requiring an anterior cervical discectomy and fusion at C5, C6, and a lumbar spine fusion at L4, L5. So again, she had both fusions, like we talked about in the first case that went for 1.5 million. She had 2 fusions. She had memory loss, difficulty standing and walking, numbness in her leg. She was unable to work due to her injuries. The plaintiff asserted negligence in allowing and permitting a large portion of the lobby ceiling to be in a state of disrepair. The defendant argued that the accident was staged by the plaintiff and others. It further asserted that the surgery on the plaintiff's neck was done to address degenerative conditions. The lumbar surgery was poorly indicated, and neither surgery was causally related to any trauma associated with the ceiling collapse claims. At trial on liability, jurors found in favor of the defendant. Oh, wow. So she lost on liability. That's interesting. That's interesting. I mean, Brooklyn usually is a good venue, but maybe they had some kind of evidence that it was some kind of a staged or fraudulent case, because if you have a ceiling collapse, it's not that difficult to prove. Usually, if you have something going on with the ceiling, cracks, there are prior complaints that the ceiling isn't fixed, or it's fixed, but it's not fixed properly, it's just kind of plastered, and then all of a sudden the ceiling collapses on someone, I mean, that's usually the building's fault. So I'm not sure exactly why they're saying that, that they weren't at fault. I'd have to look at this. This might be an interesting one just to look at, just to see what the arguments were. But again, a defense verdict. Wow. So recently it's been tough out there. It hasn't been, we only have one verdict, and it's from Westchester of all places. Let's see some of these other cases. Look, another defense verdict. Oh my God. This is out of Nassau County. Another defense verdict. I got to find some good verdicts for everybody. Everyone's going to think not to bring any cases. Oh, here's a plaintiff's verdict. Here's a nice one. A railroad accident. This was actually in federal court. And what happened here was he was a locomotive engineer for New Jersey Transit Rail operations, and he entered the cab of his assigned train on a hot and humid day. The cab's air conditioning unit was not working as it was blowing only hot air. And he reported the problem, and then a train master determined the temperature in the cab was 114 degrees. And though he indicated that he had a health condition that could make it dangerous for him to operate a train in such heat, he was ordered to take the train out and to conduct the train anyway. And then he felt lightheaded and nauseous, had difficulty breathing. He passed out, struck his head on the metal edge of the other seat in the cab, and he suffered heat exhaustion, loss of consciousness, severe concussion, post-concussion syndrome, traumatic perilymph fistulas, cervical disc herniations, which required a C4 to C6 fusion surgery. And he sued under what's known as FELA, the Federal Employers Liability Act. And that protects train workers, just like they have the Jones Act, and that protects maritime workers, people that work on boats or shipping containers, and FELA protects railroad workers. And he asserted that he was injured due to the failure of a part of the locomotive to operate as intended, right? The air conditioner, right? Because it was broken. And that's a violation of the Locomotive Inspection Act, LIA. And the plaintiff sought damages, including back pay of nearly $500,000, $499,465, and future lost earnings of $3,310,710, right? Because he was so injured that he had past lost wages of nearly $500,000 and future lost wages. The defendant denied that it violated this Locomotive Inspection Act, claiming the air conditioning unit did not qualify as a part of the locomotive. That's an interesting argument. I mean, the whole air conditioning in the train is not part of the train, so it's like a separate unit. I mean, I don't know. Well, I guess it didn't fly because this was a plaintiff's verdict. That argument didn't work. It also asserted, this is the defendant's contention, the defendant also asserted that a regulation requiring that the locomotive cabs be equipped with proper operating air conditioning units did not apply to the locomotive at issue. I'm not sure why, but I guess they're saying that this regulation says that maybe it was grandfathered. This was like an older car and it didn't have to have air conditioning. But anyway, a jury found in favor of the plaintiff on both claims and determined that he was 55% negligent with regard to the FELA claim, the Federal Employers Liability Act. So they found the plaintiff to be somewhat negligent, but the total compensatory award was pretty high. The compensatory pain and suffering was $7,500,940. That's the pain and suffering. The past wages were $450,000. The future wages were $3,667,000. And the total compensatory award was $11,618,129. So even if the plaintiff is 55% at fault, he would, receive close to half that, right? Half of 11 million is still like close to 6 million. So this is almost 12 million. Yeah, so it's almost 6 million. So it's still not bad. Still a good amount. And in federal court, which is a tough place since you don't get jury selection in federal court. But I guess they had a good case under this FELA, which are very, very good cases. Let me actually see who was handling that, if it says which attorney. Oh yeah, they list who the economist was, who the neurologist was for the plaintiff. They list an ear doctor. I believe that's an ear doctor, an otolaryngologist, and an ophthalmologist. I guess he had a lot of almost like traumatic brain injury symptoms because he had an eye doctor, he had an ear doctor, he had all these specialists, and it lists railroad. He had a railroad safety engineering expert, actually out of Georgia, flew up and did this case. This was a case in the Southern District, so this is in New York, in Manhattan. Yeah, and his lawyer was somebody out of Connecticut. I haven't heard of his lawyer, but I guess it was a pretty good lawyer if he got that kind of a result. That's a nice result, almost $12 million. So I'm looking into these cases. I haven't, handled too many FELA cases on my own, although I know other lawyers who handle them, and I've partnered with lawyers that have handled cases like that. But they're interesting cases. Okay, let's see what other cases we have. Here's a case out of Suffolk County in March of 2023. And this one involved a plaintiff. It was a man, a 44-year-old man. Actually, I'm sorry. Oh yeah, it was a man, yeah. A man, Edgar, his name was Edgar. And he was performing work at a construction site when the defendant was a general contractor, and he fell from a makeshift scaffold to the concrete surface below. So it's a labor law claim. It's a construction accident claim, construction site safety. And he claimed to suffer a laceration to his left eyelid, requiring 14 sutures, diplopia, left fourth cranial nerve palsy, radiculopathy at the L4-S1, spondylosis at L5-S1, bulging and herniated lumbar discs, bilateral lumbar foraminal stenosis. That just means narrowing stenosis, and the foramen is those holes that you have where the nerve roots come out. Lumbar myofascial pain disorder, head trauma, subjective headache disorder, hearing loss, tinnitus, nasal and supraorbital fractures. The plaintiff said he required a lumbar fusion, and this is the lower back, at L4 to S1. So that means L4 to L5, that disc was fused, and then L5 to S1, which is the final disc in the entire spine, that was fused. So you had it's two level, but that's a major surgery. And he also had surgery to repair his nasal fracture. So he reportedly was unable to return to work. He asserted negligence in failing to provide a safe place to work. The defendant argued that the plaintiff was able to perform the activities of daily living and return to gainful employment. It denied that the plaintiff's claimed lumbar injuries were related to the accident. The defendant brought a third-party complaint seeking indemnification against the plaintiff's employer, which was a drywall company. And after a jury found in favor of the plaintiff on liability, I'm assuming, the parties settled for $2.9 million, so almost $3 million. So it's a pretty good settlement. He's a 44-year-old man, and this was a case out of Suffolk County, out by where the Hamptons are, Central Islip, out there. So it's a little bit more conservative out there, but that's a pretty good result. And I see it says who the defendant used. The defendant used a neurologist, and it used an orthopedic surgeon that this orthopedic surgeon that the defendants used, I had him on one of my cases. Actually, the case that I settled in Brooklyn for, I think, $1.5 million. He was the expert on that case for the defendant, and they also used him on this case. He's a doctor he's actually a doctor from out in Suffolk County out there in Long Island. So this was a pretty good result. Let's see if we have time maybe for one more case, one or two more cases. We're in March now. This is just a search. This is a search. I searched for the word fusion, and these were cases that involved fusions. Yeah, according to this result that I'm seeing, there's only one more case in 2023 involving fusions, and this case is a premises liability case at a train station, at a transit station, and it actually happened. The lawsuit was in Kings County, which is Brooklyn, so it's a Brooklyn case again. And I recognize the plaintiff's attorney. I recognize the judge as well. Okay, so let's see what happened here. Okay, this was a plaintiff. It was a lady. Her name is Luz, and she was employed as a tax auditor, and she suffered permanent injuries resulting in chronic, debilitating pain when she slipped and fell down a staircase at a subway station owned and operated by the New York City Transit Authority and the Metropolitan Transit Authority, which is the MTA. So New York City Transit Authority, NYCTA, and Metropolitan. The plaintiff reportedly suffered multiple disc herniations requiring 4 extensive back surgeries, including a laminectomy, 2 lumbar fusions, and a cervical discectomy. Wow, so that's a lot of surgeries, 4 back surgeries. According to the plaintiff, she developed a life-threatening infection as a result of one of these procedures and was left with a permanent, debilitating, complex pain post-laminectomy syndrome. So complex pain syndrome. That's like complex regional pain syndrome, CRIPS, CRPS. We've had some cases about that. Now, the plaintiff claimed that the defendants failed to properly maintain the subway station, including the staircase and walkways, and allowed a dangerous foot trap condition to exist on the stairway, resulting in an impediment to persons lawfully ascending, going up, or descending, going down the stairs. So the defendants denied liability, what a surprise, and argued that the snow and ice condition of the subject stairs was open and obvious, that its snow removal maintenance crews had been to the subway station several times during the week-long snowstorm, which dropped 13 to 14 inches of snow on the city with below freezing temperatures. And regarding causation, the defendants noted that the plaintiff had prior lumbar injuries, that her lumbar surgery was performed 3 years after the subject fall, and that her cervical surgery was performed 4 years after the incident, and that after a brief period, she returned to work. And it was a bifurcated trial. So the jury determined the defendants were negligent and that the plaintiff had no comparative liability. And then the result in the case was a verdict for the plaintiff, and the total amount was $8 million, according to this report. Now, it doesn't say, oh no, it does say, okay, here it is. So the compensatory pain and suffering was $4 million. The compensatory past wages were $550,000. The future wages were $3,450,000. So I guess when you add up the pain and suffering being $4 million, I guess that's total, so maybe past and future. It just says compensatory pain and suffering. It doesn't say past and future, so I'm assuming it's both. So $4 million, and then you have $4 million more in wages, so altogether $8 million. So that's a nice result. Nice way to end the year, or begin the year. This case was from January 26th of 2023. So there you have it. That's a year of cases, according to this database anyway. I'm not certifying or, I'm not saying it's complete, but according to this database, these are all the cases when I searched the word fusion that showed up in New York in 2023. Okay, everyone. I hope this was helpful. Let us know what questions you have. We are here for you. Please like and subscribe to our channel. Drop us some comments. Show us some love. We'll go live. Feel free to join us live and ask us some questions. We're happy to help. Our goal is helping serious injury victims and families, and we are for you. Any questions, you could also text me, 347-566-9595. I'll usually text you back the same day, schedule a call, jump on a call with you, and give you some knowledge, give you some insight, help you. I work with a lot of lawyers, not only in New York, but all over the country, and these are some of the top-rated, absolute best trial lawyers. And then, I'm happy to partner with them and handle your case and have that way you are in good hands and you have a good lawyer representing you to get you one of these types of results, like 11 million, 8 million, 4 million, big results, the absolute maximum that you can get. Okay, everyone, have a great day. Talk to you very soon. Bye-bye.